Making your lunch, but we're going to go ahead and get started so we can make as much room for this conversation as possible. I'm Amanda Watson. I'm the Assistant Dean for the Law Library and Information here at Harvard Law School, and I'm so excited to welcome you to today's Harvard Law School Library Book Talk, Reading for the Constitution, Why I Chose Pragmatism, Not Textualism, by Stephen Breyer. And you can get a copy at the library, of course, or at the Harvard Coop. We'd like to thank Dean Goldberg's office for their generous support of the Faculty Book Talk series, and I want to thank everyone who makes this event possible, from our housekeeping to our catering staff, and especially our wonderful librarians, Katie Conway, Sarah Newberg, Lisa Lilliott, Caroline Waters, Catherine Biondo, Deanna Barmakian, Leslie Diana Jones, Debbie Ginsberg, and the architect of these events, Maya Bergamesco, for their hard work. Before we get started, I want you to take a moment. Anything you have on your body that makes noise, please turn it to silent so we won't be interrupted. And now I can do the great part of welcoming our speakers today. Martha Minow is a 300th anniversary university professor at Harvard Law School, where she teaches courses on constitutional law, fairness and privacy, and law and equality. And Stephen Breyer is the Bryan Professor of Administrative Law and Process at Harvard Law School, and as some of you may know, a former Justice of the United States Supreme Court, Associate Justice. He has written extensively on wide-ranging subjects, including administrative law, regulatory policy, comparative constitutional law, and statutory and constitutional interpretation. So I'm going to turn it over to our speakers for discussion. Thank you so much.
Thank you. Thank you.
Well, it's such a pleasure to be here. I give my thanks to the Dean's Office and to the library, just fantastic, and to Justice Breyer, who has become a center of this institution in his return to full-time teaching after having served not just on the Supreme Court, but also on the Court of Appeals, and also in the Senate. And in fact, I want to turn to a little bit of that larger history, Justice Breyer, if you're willing. What does an appellate judge do?
Before I say what an appellate judge do, don't take from the fact I'm postponing that he doesn't do anything. I mean, they do. But and thank you, Martha, for coming, and thank you to the library too and the school. And but before I do that, I want to show you something. You want some advice for your life, I'll give you some advice. And the advice that I got when I became an appellate judge, the best advice I got was from David Bazelon, who was a good judge in the D.C. Circuit.
My boss.
He said, this takes a long time being a judge.
Yeah.
You're going to be here a long time. And what you better do, and that's true being a lawyer too, and they're all kind of, okay? He says, the main thing I can tell you is get an interest, get a hobby, and let it have as little to do with law as possible. Right. And so what I did, which is a little nutty, I agree, but I spent quite a lot of time learning French. How many speak French? Only 2 people? No, 5, 6, good. Because here's the book in French. And I just came back from there. There it is. And moreover, it's a better title in French. It's Interpréter la Constitution américaine, la lettre ou l'esprit. So at least 6 people in this room know that is a long intellectual history in France. So it's on television, I really like it. It's showing off like mad. and how many of you speak a foreign language? Do it. I mean, honestly, it will make your life a lot better. And if you don't know Spanish or French or whatever language, learn it. You want the secret of how to learn it? I was told this by the French ambassador and also by the Giscard d'Estaing, who I sat next to once. He speaks perfect English. All you have to do as soon as you get out of your first year. The first year what you have to do is you review your notes. But after that, what you do is you read in the foreign language for a half hour a day. And maybe you can't do it every day, but as many as you can. And that's it. And in a year or 2, you will speak the language. And then you will go to the country, maybe it'll be in South America, or maybe it'll be in Asia. I don't know where it's going to be. But and they'll say, oh, you really speak it well. And they're not just being complimentary, it's because you spent that half hour a day. And Giscard d'Estaing, he speaks English perfectly. And I asked him how, he said, half hour a day? Okay, now you got my advice. Now we can go into this stuff. And what does an appellate judge do? See, did France help? Yes. Because I start this thing by saying I was in France and I read in the newspaper a story of a biology teacher in high school who was traveling from Nantes to Paris. And in the basket down here, he had 20 live snails. So the conductor comes up, and she's looking at the basket, and she opens it up and says, "Oh, les escargots," okay? You know that word. And she says, "Do you have a ticket for the snails?" He says, "What? Ticket for the snails?" He says, "Yes." He says, "You don't have to buy a ticket. Just read the fare book. It says no animals on the train unless they're in a basket, and you bought a half-price ticket for the animals." So he said, "But they're talking about dogs. They're talking about cats, maybe a rabbit."
How big are these snails? Okay.
Not that big usually. And they're delicious. But no, forget that. But they're not talking about snails. He says, "Well," she says, "is a snail an animal?" See, I tell that story to the 7th graders when I'm explaining what the court does, the Supreme Court and another court. I tell them that story, and you know, it's not so easy to talk to 7th graders. They're looking out the window. And so I want to bring them back into the room. So I say, "Okay, who's right?" I don't have to say another word. They spend the rest of the time, "Well, what about a caterpillar? What about a mosquito? I mean, this is ridiculous." He says, "Is a mosquito an animal?" And after a while, them screaming at each other about that, I say, "Now you've got it. That's what judges do." The word might not be animal. It might not be the same word, but I mean, the word is the freedom of speech. Or maybe it is the right to bear arms, but it's the same idea. That's what appellate judges do. What is the scope of those words? Do they apply in this situation, and if so, how? Exactly what the conductor did with the snails, and then they've got it. You say, I say, good, you're all ready now. Okay. Now,
Some people say that the appellate judge has the least discretion of any of the 3 levels because the trial judge, the district court judge, has lots of room around the facts and only has to make a decision with him or herself because there are no other members of that panel. And the Supreme Court has, you know, the chance to reverse precedent, write on a blank slate as if it were blank. Whereas the appellate judge is in between. So is that true? The appellate judge has the least latitude of freedom?
what he is doing, the appellate judge and the Supreme Court justice, the same, really. It's not so different. There are some differences, but not so different as people think. And the number of cases we have in the Supreme Court, 50, 60, 70 in a year. Why? Because as you know, why is it your whole first year class is all about state law, contracts, property? Why? Because that's where the law is made. And I tell that to the law school students that I like to speak to. And I say, look, I did this once at Yale. And I say, where is the law made that affects you and your family? And I expect them to say, and they will, some say Washington. I say, no. You're from California? It's Sacramento. How much? I said 90%. I don't know. But that's where it is. So you want to help your family, you want to help your friends, go back to Sacramento, San Francisco, Los Angeles, wherever, Des Moines, but it's not Washington. They want you to say, oh, but the most important. I say that's what they want you to think in Washington. And the newspaper people like to be in Washington, so they'll write that stuff, but it isn't necessarily the most important. I said, well, I asked Justice Liakis once, I said, how many cases are there in courts in a year? He said, well, he said, I think about 18 million. Really? He said, but they're mostly all traffic tickets. And I said, how do you know that? He said, I made it up. But later on, I found it not so wrong, not so wrong. But most of them do not involve federal law. They involve state law. And this court, where I was for 28 years, I mean, this court deals with federal law. That is, federal statutes, administrative stuff, and the Constitution of the United States. Okay? So it's a small amount. You say, how many get to, you know what happens in a courtroom, really. My brother is a trial judge, and he's fond of saying that I know nothing about law, and he's the only one who does. And he's in San Francisco. And he says, yeah, that's where the law is. Because what? What's it about, basically? I say, basically, it's about solving disputes. People, I say that to the 7th graders again. You ever get into an argument with your family? Yeah. Brothers, sisters? Yeah. Do you work it out? Yeah, usually. Forget about it. You know, yeah, we forget about it. Okay. I say, but sometimes people just can't forget about it. Maybe it's a crime, maybe it's a huge amount of money or an accident or something. And then they go to a person, and that person will help them get over it. And that person is called a? Right. See, you all know. That's how you got into this school. Many of them make the mistake and say a judge. No, it's a lawyer. And that lawyer is trying to help you get over your arguments. Trying. He should. But not always. Oh, but even if he doesn't. Say, okay, then we go to the next step. And the next step looks like a court. But wait. Before you go into the court, you do something. You walk up some, what? Not all courts, most courts. You walk up some what? Yeah, and where the 90% more cases settle?
On the
Got
steps.
it? Yes, you got it. Okay, that's it. But if you won't, then you're in the courtroom. And when you're in the courtroom, of course, the people, as you know, the people who decide the facts are almost always called the... Good, you passed your first year. Okay, so then, and the judge, well, I say, what do you do, Chuck? What do you do? And what Chuck says he does, since they're deciding the facts, is what? What's he doing? He's telling those people what? What's he telling them? The law. Okay, now you've justified your presence in this law school. And if you read your notes every day, you will have no problem getting to your second year. Read what you wrote down, read it at the end of the week, you'll be fine. Don't worry about it. And your worrying will beginning to go away. And then you'll say it's boring. But nonetheless, okay, got it? You tell them the law. So then one side wins, the other side loses. The lawyer who wins, what does he think of the judge? No, wait. What about the one who loses? What does he think of the judge? Right. He thinks he's a real idiot. Does he say, Judge, you're a real idiot? No. He says, oh, that I see, Judge. Yes. Then he walks out of the room, tells his friend, that man's an idiot. So what does the winning lawyer think of the judge? What? He thinks he's great. No. No, he doesn't. He thinks he's a good lawyer. Got it? All right, that's how it works. And the losing lawyer can go where? To a court of appeals, of course. And if he doesn't like it there, he can go to another court of, sometimes. And maybe he goes to the Supreme Court of the state. And so now, where this long thing is getting to what we do in the Supreme Court, because finally you're in the state Supreme Court, or maybe the Court of Appeals, Federal Court of Appeals, or not. There's nowhere else to go. Where is there to go? Supreme Court. And so maybe there are, roughly, if I exaggerate a little to make it easier, maybe every year there are, let's say, I don't know, 800,000, a million, 80,000. I want an 8 in it. And maybe it's 80,000 cases in the highest possible courts, short of the Supreme Court, and only one place to go. And of those, 8,000, roughly, 7,000, 8,000, each year ask us to hear the case. But we have discretionary jurisdiction. We don't have to. 8,000 request it, we grant 80. Now, do you see? See, 80 cases, and are they always the most important cases? No. Sometimes, yes. And but they're all over the place. They're all over the place. The things that are of importance to you and your sisters and your brothers and your family and your friends. They're all over the place. And that's what you will begin to get how to grasp all these and give your clients, etc. So you see 80.
You said that the Supreme Court is not so different from an appellate court, but in some ways it is different.
Well, the question is, what 80 did we take? What we took, if you want the whole system, is they asked us, 80, see that's about 150 a week. We each have 4 law clerks. We pool most of them, and they go, 150 a week is about 5 per 30. I'm not great at math, but they're about 30, and divided into 150 is about 5. And they'll write memos. And so what I get every Wednesday is I get a stack of memos like this, and I go through them. I go through them till in about an hour or two I'm down to this. Now, how did I do that? How did I do that? I'd like you to think it's because I'm a genius. I'm not. But that's not the reason, and I'm not. It's because there's a criterion, and that's what this long discussion that we've just had is about. I want you to see the criterion. And almost always the criterion is, did the lower courts come to different conclusions on the same question of federal law? That's not 100%, because if some lower court judge set aside a law of Congress as unconstitutional, we'll probably take it. And maybe we take Guantanamo, even if there weren't a division. But that's the primary criteria. And so now you see I get it to here. I hand them to my law clerks as memos. I say, I want you to answer these questions. And then maybe a few days, a day or so later, we'll discuss the issues in these I've saved. And now we're at Wednesday. Wednesday, the Chief Justice's memo comes around, all the ones he wants to discuss on Friday. And then anybody can add, any one person can add any case, and we'll end up with a memo by Friday morning, which probably has 10 to 15 cases on it, which are real. We're really deciding those. And then when we're in conference on Friday, we go around the table in the cert part of the conference, and the chief says this issue is da-da-da, and then it goes to Clarence Thomas and to me and Alito and Sotomayor and Kagan and Gorsuch and Barrett, Kavanaugh, Ketanji, who was my booker, right? Great. We go in order. Nobody speaks twice. But it's very brief, very brief. And 4 votes is a grant. And less than 4 votes? No. But anyone can hold it over. And if I want to hold it over, I can. And then I can write a memo. I'll probably write a memo to the conference and say we ought to take it because of. And if they still aren't convinced, I've lost. We didn't take it. I thought we should. And I'll probably publish the memo, but that's just ego, probably. And I mean, why? I lost. I was writing it for them. I wasn't writing it for you. And usually published, but.
How much of the decision to vote to grant certiorari is based on a prediction of, is there a 5th vote to vote the way that you want the case to come out?
Do you want the case? Look, 40% of the cases used to be anyway. When I was most of these 28 years, I was there with a different group of people. Sandra O'Connor was there, and David Souter, and Tony Kennedy, and me, and others, you know. And it was, it still is. They get on well. They get on well, but or pretty well. But it was. Okay, so I am not always certain. I don't necessarily have a preference. So with a lot of these cases, 40% unanimous, maybe 50% unanimous. You know, it's a tough issue here.
Sure.
It's Oracle versus Google. When we started with Oracle, I'm most proud of that, because when I started with Oracle versus Google, which was a copyright case involving certain algorithms written in the Java language, I thought Java was a place near Indonesia, or at least there. That's what I thought. It took me 2 years. I went through 4 law clerks before I had a glimmer, you know? And what I wanted to know when we decided that was unanimous opinion. I wanted to know what the experts thought. There was a brief by Mitch Kapor, who created Lotus, and there were experts in there. I wanted to know what they thought of not necessarily thought the opinion was right, but did they think we knew what we were talking about? Yes. By the end of those 2 years, they thought we knew what we were talking about, and I think we did, actually. It's not it's a little bragging, but I think we knew to some degree. But you see, I'm not going to necessarily know when we grant it. There's a split, grant it. And Justice White used to do more when you were clerking. Absolutely. He'd want to grant everything in sight.
It's true.
And Sandra would always say, we aren't granting enough, and so forth. Okay, now we've granted it. Now what happens? They start to write. They write briefs. Why they're called briefs, I don't know. They're not brief. but there's a blue one, they're wrong below. There's a red one, they were right below. There's a yellow one, I told you before, I'm telling you again. And there's a gray one, that's the government, always gray. And light green, that's amicus curiae. You can write one. Anyone can, send it in. And light green for the blue, and dark green for the red, okay? And usually in a case there may be 12, 14, 15, but sometimes there could be 100. Mm-hmm. Okay, they gradually come in and they're not so brief. And I always start by reading the yellow because it's going to say the same thing as the blue but shorter. and so I'll read that, and then I go to the blue or the gray or so forth, and I will look at, even if there are 100, I will look at them. This time I'm not relying on the clerks. I'm reading them. Well, going to read 100? Well, I'll try. And you go through and see, is this one saying something different? I read C. Mitch Capor, I know who that is. So I say, yeah, I'm going to read that, I'll tell you. And it was good. But sometimes they just want to say, hey, the AFL-CIO is in favor of. I say, thank you very much. But I'm trying to learn something, you say. And so I will read these cases, and I will divide them among my clerks. And we have, as you know, first 2 weeks of October, November, December, January, February, March, April, and 2 weeks each. Monday, Tuesday, Wednesday, Monday, Tuesday, Wednesday. It used to be hour.
Hearing arguments in the cases that have granted for review.
Exactly. So I know where I'll be, and I'll know I'll be sitting on that bench at that time, and I'll have read the briefs, and my law clerks, I'll phone them beforehand, or I'll talk to them, and I'll say, I want you to write a memo on this one, and it says at least, and then add what you want. And you can say anybody who's right or wrong as you wish, because I want them to read it, look things up, say what they think, and before I go into that room, the courtroom, I have had a talk with all four. And I like, it's just style. I like talking to them all together because they're fun. They make your life, a little bit nicer. And so we talk. So before I'm on that bench, I have read the briefs pretty well. Not every brief. I've skimmed through if there were a lot of, but then I've talked to my clerks, and they've read them pretty carefully, without too much guidance from me, except to answer certain questions I had when I read them. And then we talked again. Everyone's done something like that, in all likelihood, and so we're fairly well prepared. So that half hour is not for them to tell us this is the big issue. We think we know. It's not for them to tell us something new. If it was some great new thing, why didn't they put it in the briefs? Okay? So it's for us to ask questions, and that's what we do.
How much of the questions are really trying to argue to your colleagues?
I would say, for me, people can have different preferences. For me, the best kind of question, which comes up occasionally, I don't know the answer. You see? I think the lawyer knows more about it than me. That is actually a correct thought. Imagine it's a bankruptcy case. Imagine it's, easy. And I think I can put it in a way that will get the lawyer away from what he's supposed to be doing, which is defending the client, and I can get a truthful answer. And go look at the Second Circuit courtroom. If you've never seen it, look at it, because the bench is here, and it was Learned Hand, and I think Frank, who wanted it designed that way. And I can look you in the eye. And that makes a difference. We're trying to get a conversation. When you get that conversation, which is only occasionally, it's fabulous. That's the best kind of question. Second best, you're trying to tell your colleagues where you're coming from.
Yeah.
That's important sometimes. if you can get them away from thinking where they're coming from. And you want them to, and they will. They'll learn something. The worst kind of question, which I do confess sometimes I've asked, Nino was worse, is you think it's funny.
Yeah.
Don't do it. I learned that in the First Circuit. I asked a question I thought was just a riot, and the person was in jail for swindling, I guess, 4,000 widows and orphans. But the lawyer for that particular individual said, well, even someone in prison has the right to a fair. Oh, why did I do that? No, forget these jokes. Don't do it. And another worse kind of question is you're trying to show you know more about it than they do. No, please. Or you have an answer to their argument. No, please. You have enough dominating. It's my opinion. You have enough dominating that oral argument. It's not for you to show how clever you are or what you think. So it's to find out something. Okay?
A great dimension of this very wonderful book is that you treat separately statutory interpretation and constitutional interpretation, though you do talk about the role of purposes in both. So what's similar and what's different in interpreting statutes versus the Constitution?
That's why I put in a chapter on McCullough versus Maryland. Marshall has it right there. This is a constitution. What does that mean? It means it better last for a long time. It means for me that practicality matters. It means, for me anyway, that there are certain values that are embedded there, and the words are more abstract than in most statutes. Not all. Try antitrust. And try some of the Administrative Procedure Act. But, yeah. And so then, a good book I read by Professor Giap, was that his name, is what the founders thought. And he says they were so far away from anything that we argue about today. Almost, what was the argument between Madison and Jefferson? Should the words be interpreted narrowly or broadly? It has nothing to do with living constitution or originalism or textualism and so forth. So why write this book? Well, part of it is probably 40 years as a judge. Maybe I've learned something. Maybe not, but maybe I have, and maybe I can get it across. But more than that, it's because we have this thing called, which I call a tidal wave, but it's textualism, literalism, originalism, all the same thing. Be literal. Nino says, and says, and you want the real argument there? What I think it is, when we were in Lubbock, Texas, at the football stadium, I think they'd not seen a Supreme Court justice, and they thought there was going to be a football game. But Nino and I were talking, and they saw that we liked each other, that we were friends. And they also, I'd say to Nino, because I'd say, George Washington didn't know about the internet. And Nino would say, I knew that. And then he would say, the argument is not really, no, it's you have a system, me, that is so complicated that nobody other than you can work it. By that time, he realized I was serious. I was not just trying to achieve a result. And he said, won't work. Impractical. I said, that maybe. But if we follow your system, we will have a constitution that no one would want. And who's right? And I wanted to leave them, and I think we did leave them with the idea the future will decide. Thank you. That's what I tell the 7th graders, the same thing here. This document is not mine, it's yours. And you are the ones who are going to have to decide. You are the ones who are going to have to figure it out. So I thought I'd put some of this, and maybe it would convince some people, and maybe it wouldn't. And I said at the end of the introductory chapter, which is a little corny, but which I think is true, is that if you ever, has anybody seen the Book of Kells? Do you know what I'm talking about? Yeah, it's in Trinity College. It was written in the 9th century by some monks on the island of Iona. And it's beautiful, absolutely beautiful. And there is a book I read which said the reason that they wrote that book of Kells is that a great darkness had descended upon Europe, and they wanted to preserve a ray of light. I said, sometimes I think of that. That's a little overstated, but nonetheless, sometimes I think of that. And I want at least the arguments to be there. I want people to see how I at least thought that these statutory cases ought to be approached. And of course, you read the language. If the words of the statute, if the word is vegetable, that does not mean a fish. No, no one thinks it does. But if you're in the Supreme Court of the United States, it's not going to be so clear exactly what it's referring to. And at that point, you might look at a few other things. You might look at, for example, what the purpose was of the individuals who wrote this. Where did it come from? What was the argument about? You might look at consequences. What will happen if we do it this way or that way? And what will happen to the values that still underlie this document, which are not so difficult to find? And other things too. History depends on the case. Depends on the case. And I want people to see how. So this book is filled with examples. And why is it filled with examples? Because I know perfectly well, I used to teach years ago, and I taught in between. I know that there are 90,000, or no, let's be honest, 90 anyway, or maybe 900 law professors who think they know more about this than I do. And they might. And they might. But they're not going to get around. I can't give in to that. So what I say is, I'm going to show you what I do. I'm going to show you with examples what I do. Now there, I have some experience. 40 years counts for something.
But some people, we're going to turn to questions in just 1 minute, but I can't without asking you, some people will say your view of purposes and consequences is losing, and it's all politics.
That's a big question. It's a big question. If you read the newspapers, you think it's all politics. And then I go and say, no, 40 years, 28 years there. I mean, no, it's not politics. Well, they say, please, you're just trying to protect the institution. I say, no, that is my honest experience. Well, what is it? I say, here, when a vacancy arises, the president is going to appoint someone. Every political group in the country that has an interest goes out and tries to get someone they want. They're talking to the president, or they're talking to the senators, you see. And the person they want will be a person who will not think he's being a politician. If he's appointed, he or she will think, I'm deciding this as a matter of correct jurisprudence. Jurisprudential ideas. So what they want is a person whose jurisprudential ideas will end up with decisions that they think they'll like politically. Okay, I say that's fair, because that is my experience. That's important. And also, I think what they used to call political science. That's not politics. But why is that important? Well, you're going to have to answer this question. What do you think? What do you think this country's about? What do you think your country, here, what is it? What is it like? What is it supposed to be? What are its ideals? That's not politics. That's not politics, that's your life. And that's what you've learned over time. And then, of course, it does matter, I think, where you're from and how you've been brought up. I grew up in San Francisco. My parents were from San Francisco. This is my father's watch. It says to Irving Breyer, SFUSD, legal advisor of the San Francisco Unified School District. By the way, Ketanji's father was a lawyer for the school board, too. So I always thought, well. And it says 1933 to 1973. That's how I grew up. I went to Lowell High School. It was a public high school. I went to Stanford. I came here. I've had the life I've had. And everyone has. And that's going to shape what you think? Yes, to a degree. You might try to get it to put it aside as best you can, but you can't jump out of your own skin. And so there'll be some of that, of course. And then there is, of course, what Paul Freund said, and I think what Paul Freund said is the best explanation of the role of politics in the Supreme Court that I've read or heard. And he said politics, for a judge, he says, no judge decides a case according to the temperature of the day. But every judge is aware of the climate of the era. Yeah. Now we can see, yeah. New Deal Court, Lochner Court, Warren Court. There's something to that. But not too much. Not too much. Not to the point where Alito, good, not a bad paragraph in his Dobbs opinion. There are other paragraphs I don't necessarily find so fabulous, but nonetheless, yeah, you don't want a judge who will substitute what he thinks is good for the country for the law. I say, I agree with that. I agree with that. People have to try there. But you see, Freund sort of catches that. He catches that. And then there's some real politics. What about Loving v. Virginia, miscegenation case? It came up first after Brown, pretty quickly after Brown v. Board. And you know who was enforcing Brown v. Board? Nobody, okay? It took a long time. Very hard. Congress didn't help. The president didn't help. Not much, at least not at the beginning. And it took the whole country to begin with what I lived through. You know, Martin Luther King, Rosa Parks, the Freedom Riders, a long time. That's another story. Okay? But Frankfurter told the court the first time the miscegenation case came up, he said in conference, don't take it. That's what the South is desperately afraid of. If we take it now and we say that of course it's unconstitutional, a law prohibiting miscegenation, of course, God knows, they'll never follow Brown. That's what he said, basically. When they didn't take it, they took it a few years later. That's Loving. That was politics. And politics, Taft. Taft, who had been president of the United States and had a court where Holmes sat and Brandeis sat, and a few others too, and they had many, McReynolds was there with quite different views. But Taft, in a letter to Sutherland, says, of course, I hope the new appointees, I hope they'll know something about law. He said, this is, after all, a legal job. But he said, I hope also they know something about the higher politics. And just what is that? The higher politics. And you want me to say it's phony? No, I won't say it's phony. You want me to say it governs everything? No, it doesn't. Very little. And just what is it? And the reason I found this book by Janop so interesting is it catches one view you could have of the court system over time, the appellate court system. There's something to be said for what is a kind of special role of the Supreme Court, one of the three institutions, etc. But you go back and read the Federalist, you read the Federalist and you see that really Hamilton is saying, well, somebody has to decide what the bounds of this Constitution are, and if not, it's a beautiful document, put it in the Smithsonian. No, he didn't say that because there was no Smithsonian at that. All right, but in any case, you see what he's saying? He said, the president, should he have the last word? No, he'll just say everything he thinks is right. Everything he does. Congress, after all, Congress is elected. Yeah, well, Congress, he says, they're experts. They're experts. They're experts on what? They're super experts on popularity. Believe me, they know popularity. If they don't know popularity, they won't be where they are very long. And that's just it. And so this document is written for the least popular person in the United States as well as the most. Okay? So there's only one group left, the judges. And what does he say about the judges? Well, this is sort of a legal job. And he also says, hey, we don't have the power of the purse, they don't have the power of the sword. So not very powerful. Good. Because at that time, if you read Janop, nobody thought the judges would be having the last word. Very few did. That's one historian's view. Others might have thought the contrary, regardless. Yeah, you see? And I can sit and think, and sometimes I used to think in the First Circuit, we talk about, I have a great friend, Michael Boudin, who was chief judge for a while, and he came, look, where are we? Where are we? I sometimes think where we are is one of the things that Janop says. He says some people did think this, that law itself is just this huge mess. And the judges are called in to straighten out this much. And they straighten it out a little bit. And now we have a clearer picture. And then 10 years later, it's going to be in a mess again. And over here, it's still a mess. And there we are. And that view, which is, I'm being slightly facetious, but read what some of the founders thought. They didn't think they thought that's just, it will develop over time. How? Well.
Let's hear what the students think. Let's have a question. Who has a question? We have someone here, and maybe you can identify yourself. There's a microphone coming your way. Here it is.
Hi, I'm Kyle Lewis. I'm a 1L here. And there's a bunch of ideas bundled under the phrase, you can't jump out of your own skin, that you mentioned. And I wonder, if an interpretive method should help you try, or one of the priorities for an interpretive method should help you get closer, if that matters, or if it's, other considerations are more important there.
No, it should help you try. It should help you try. You're not going to do it completely. But I used to think, for example, look, I have had the life I've had. I thought, I'm so reasonable. I grew up in San Francisco, and I worked here for a while and lived in Cambridge, and why doesn't everyone agree with me? And then I thought, it's a big country. It's a big country. And my mother used to say this, don't be rude, I'm not trying to insult anybody, but she used to say, we have in this country every race, every religion, and every point of view, and she added, there's no view so crazy that there isn't somebody here who doesn't hold it. And then she'd say, they all live in Los Angeles. That's because, that was, you see? And then, what are you trying to do? You're trying to get something, I think, that will work, that is consistent with the language, that there isn't a secret to it, And it's if you're there, and many of you will be law clerks, and you'll see how this going on, and you'll do your best. And you could be a law clerk. There are thousands of judges. You don't have to necessarily be on the Supreme Court as a law clerk. You can find out about law in many, many ways, the practical parts and how this fits together. Is that an answer? Is that a good enough answer? That's sort of what I think. You try.
One more question.
Oh,
I think we're going to have to
We're gonna
end it.
We are? I thought we had
I'm
to
getting
1:30.
mixed messages.
I think we're gonna end it now. And thank you so much. Thank you for all of
I
your
thought we had till 1:30.
insights. Yes, yeah.
You do, but it's only
Thank
1:50.
you.
Oh, thank you.